Okay, so let's start our class. First, we are going to deal with the previous 3 year question. What questions are asked in IPR. So once we will analyze it, and 14 questions were asked in last 3 years. So first we are going to deal with that, and after that, we are going to read this intellectual property rights in detail. So good thing is that they are, I mean, still in entrance they are asking some basic question. They are not going much deep. They are asking some basic questions. They are asking the years and on what thing we are giving copyright, on what thing we are giving patent. So these are the very basic questions which you people should have command over that. If you will read 1 2 time, you can easily understand the concept. So these are the basic concepts. So good thing is that they are not going in deeper, but still I have made your slides in little detail, so if might they go in deep on this topic, so still you people can solve it. So let's begin our let's look the previous year question. After that we will move to slides. So first question is the under Patent Act 1970, patent is granted for year. Here it is asking for how much year we can grant patent. That is for 20 years. Next is under Trademark Act 1999, the trademark is granted for. So for which thing trademark is granted for? So it is granted for 10 years, and but may be renewed from time to time subject to the provision of that. So by under trademark act there are provisions, according to that we can renew, but they are only giving for 10 years first. After that you should have to do renewal for it. Next is World Intellectual Property Day is celebrated. So World Intellectual Property Day, you people have to remember, that is 26th April. Next is product patent in India was introduced in. So product patent in India was introduced in 2005. Next is industrial design, specifically refers to industrial design. हम किसे कहते हैं? Means what constitutes the industrial design. So form of expression with aesthetic appeal. We will read this thing in our slides. Next is asked about TRIPS. TRIPS is a agreement on trade related agreement on intellectual property rights, and it was done under the World Trade Organization. We will see it. So TRIPS, what is not mentioned in TRIPS, that is patent, copyright and data exclusivity. Next is intellectual property rights are in their enforcement. So we know intellectual property right is territorial based, means national based, nation based. So if someone had got some, I mean did some research and made some innovation and get patent at India, it doesn't mean it also has patent there in America. So it has to, I mean, go in their forum, territorial based, and it should be registered there. Either a person should go for patent uh, to the international forum like World Intellectual Property Organization. There, through there they can register it for, so that it can be protected at worldwide. Otherwise it is territorial based, so you have to register in every territory where you want to use your patent or whatever intellectual property you want. So it is a territorial based. Next is trade related intellectual property disputes are settled by. So we know trade related intellectual property TRIPS agreement is already there by World Trade Organization. So it is dealt by the World Trade Organization. Can anyone tell me where is the World Trade Organization's headquarter?
Geneva.
And where is the
Geneva.
headquarter of WIPO, World Intellectual Property Organization?
Sir, New York.
No. It is also based in Geneva. Their
The
headquarters is also based
in
in Geneva.
Geneva,
Geneva
sir.
itself.
Yeah, yeah. So both headquarters is in Geneva. So you should also remember. this might be they ask in your coming exam. Formula of making Coca-Cola is protected under. So formula of making Coca-Cola is a trade secret. Neither it is a copyright nor it's a trademark. It is a trade secret. कॉपीराइट हम किस चीज़ पे देते हैं? तो वो है एक्सप्रेशन पे. हम अभी इस कॉन्सेप्ट को आगे आई मीन इन नेक्स्ट while reading slide we will deal with this concept. The maximum term of protection of literary work of an individual author. So it's talking about the copyright of an author. So it should be a lifetime of the author as well as the 60 years after the death of author. 60 years. An invention is protected by, so an invention is protected by patent. So this is the last question. Consider the following statement about intellectual property right and identify correct statement. So we can exclude this. IP does not include industrial design, so we know IP includes industrial design. IP includes trademark. So here it is written not. Here it is written only patent. So we know that it is not only patent and copyright. So here we can it can come in definition. IP refers to the creation of the mind such as invention, literary, artistic work. So this is the correct answer. So can uh, so by this we have seen this. Now we will move to side. Can anyone explain me what things come under intellectual property rights mainly? Like copyright, patent, anything else you want you people know? Okay.
Yes, sir.
What constitutes intellectual property right? Means what things come under intellectual property right?
So design,
Okay,
Design, trademark, patent, and copyright.
okay. And there is one more important, GI, geographical indications.
GI, yes, sir. GI.
Oh,
Geographical Indication.
hmm. Okay, so let's begin the intellectual property right. So let's briefly look what is intellectual property right. It is a product of mind and intellect. I mean anything that is a product of our mind or our creativity. Through our creativity, through our intellect, we are creating something. So this includes patent, trademark, geographical indications, industrial designs, layout designs of integrated circuits, plant variety protection, copyright, and all these things. So how this concept came from, where we can locate this concept? So there was a very famous political philosopher of England, John Locke. So John Locke there given a labor theory that any product of my labor should belong to me. I mean anything which is product of my labor, my effort, it should belong to me. So if I am working on a plot of land, so through my labor if I am producing something, it belongs to me. So from this concept, this theory, this idea of intellectual property right can also be derived. So now first we will look what is property. So property are two kind of thing, tangible and intangible. Tangible, something we can touch, something we can feel through our senses. We can see, we can I mean touch it. So that is tangible. So one is movable and another is immovable property under tangible. In intangible we can put intellectual property into two parts, that is industrial property related, patent, design, trademark, GIs, and in another side we can put copyrights related, I mean intellectual properties. Okay, so there are some examples. So first I would like to you to understand the concept, then again we will come. So you people have seen this mark. So this what this shows that it is a trademark. Which company is this? Can anyone tell?
iPhone,
Well,
Apple,
Yeah, so it's a company of Apple. We can see
Apple.
this logo, and we can tell that this is their trade, I mean this company belongs to this by just looking their logo. Logo is a part of trademark. So what it is, patent? Patent is based on innovation. So this is created by some innovation, this fan. So it is patent, but there this design is a part of a industrial design. Then GI laddu, we can GI indication. Tirupati laddu. Can anyone tell where is Tirupati? In which state?
Andhra
Andhra
Pradesh.
Pradesh. Chittoor.
Yeah, Andhra Pradesh district Chittoor. Then Kolhapuri chappal. Can anyone tell where is this place Kolhapur?
Maharashtra.
Maharashtra.
Yeah, Kolhapur is a district in Maharashtra. Then we can see this example. So what I mean, this what is written as a Coca-Cola. This is their trademark. But this design of bottle is a industrial design. Patent is given on this making of this bottling instrument, what they use. And what is trade secret, which is their formula. So we are going to read this, and again we can come on this slide to see that. So first we are going to deal with the copyright. So copyright is a set of exclusive right. It is given to the author or creator of an original work, including the right to copy, distribute, and adopt the work. So whoever any author is creating some original work, he has the right over that as a copyright, and has the right over the distribution, has the right to adopt that work. I mean, these things are given to the creator of the original work. Then providing the author with the sole right of his work, then providing for the work to lapse into the public domain. And this is not a, this is a limited period right which is given to the author, I mean whoever is creating some original work, and after that it would be put into the public domain. So we all have read uh, in the question that how long copyright holds. What is the term of copyright?
So the maximum term is the lifetime of the
60 years.
author if it's the original work plus 60 years.
60
60 years
years maximum the lifetime.
uh, lifetime of the author, and after the death of author 60 till 60 years from his death, I mean copyright belongs to that person who has done that original work. Okay, so what are the copyrights? Whenever a copyright come, what should come in our mind? It should be some literary work, it should be some dramatical work, it should be some musical work, it should be some artistic work, it should be some cinematographic film, sound recording, all these. So whenever copyright term come, you people should think about these things, so you can easily remember about copyright. So copyright is actually given on expression, not at the idea. So you can see, take an example of like Indo-China war happened. So Indo-China war happened, was a major event, and lots of ideas and theories developed regarding the Indo-China war. So a person is making a movie on Indo-China war, that is the expression on the based of an idea of Indo-China war. So that movie, whatever dialogue they are giving, whatever way they are expressing, that is protected under copyright, but not the whole idea of Indo-China war. So any person can make a film on the Indo-China war, but they have to use their own expression. They do not copy from another films. I mean, so they can take the idea, but they cannot take the expression. So copyright is given on the expression, not on the ideas. Ideas remain same, but expression can be changed. I mean, expression comes under the copyright. So always remember the expressions are the given place in copyright. And copyright is a monopoly right, as we know, and it is given for the limited period of time. So how copyright is deal in India? Copyright is deal through the Copyright Act of 1957, and it is an economic and moral right. So intellectual property right is basically based on the fundamentally on economical rights. it is protecting the economical right. So if any question comes like this, I mean intellectual property protects what kind of right, so just go with the economic right. So economic right and moral right are protected through the Copyright Act 1957 of any author's work. So there is no process of registration of the work. I mean, copyright work is not you have to go some office and register. You have to just fix it. Whatever ideas you have to just put it into on a page and publish your work, or give it, or record it, or give it in a form of expression. Just you have something in your mind, you will not get copyright. You have to publish it to enjoy the copyright. And we have already know lifetime of the author plus 60 years is the term of the copyright given. So there is the concept of assigning of copyright. So copyright is an exclusive right to the author, but it can also be shared if you want to give it completely whatever work he has done. I mean whatever expression he has given to his some intellectual work. So he can also give it to someone through the through by writing, through by assigning someone. So assigning someone means giving someone permanently, but there is also contractual transfer. I mean giving some of part of the copyright, I mean sharing some part of the copyright with someone. We can see that many songs of the movies are sharing or transferring some copyright with the some big YouTube channels or with some others. So they are taking some money, taking some economic resource, and on that ground they are sharing those copyrights. So we can also share the copyright through contractual transfer by the copyright license, or we can also give it, assign it completely to assignee. And if someone is infringing someone else copyright, there can be option of civil and criminal remedies. So you can file a civil case, or even you can file a criminal case against that person who is infringing the copyrights. So we have just read here copyrights, and now there are also two things which is important to remember, that is broadcast reproduction right and performers right. This is mentioned under the Copyright Act 1957. So what is this broadcast reproduction right? Every broadcasting organization shall have a special right to be known as broadcast reproduction right in respect of its broad in respect of its broadcast. So broadcasting reproduction right have 25 years. So don't get confused if I mean broadcasting reproduction right a question came under the copyright. So if it is talking about broadcasting reproduction right, you have to go with the 25 years, because I mean it is specifically mentioned under the section 37 of the Copyright Act. The broadcast reproduction rights shall subsist until 25 years from the beginning of the calendar year next following the year in which broadcast is made. So broadcast rights start from the next year. I mean if I am broadcasting something in the 2022, broadcasting year will start from 23 till next 25 years. Now comes the performer's right. When any performer appears or engage in any performance, he shall have a special right to be known as performer rights. And performer rights is last till 50 years. So if a question come on performer's right, you have to select 50 years. And what are the performers? The actor are the performer, the singer are the performer, the musician are the performer, the dancer are the performer, the acrobat are the performer, juggler, conjurer, snake charmer, a person delivering a lecture. These things come under the performer. So if suppose a question goes in deep, I mean they are asking going to deep in copyright, they will certainly either ask the performers right, or they might ask the broadcast reproduction right. If they will ask, they will I mean clearly put these things in the question. So whenever these things come in question, you have to select your answer accordingly if they are asking their years. Okay, so this was the copyright. Now we are going to the patent law. We are going to study. So patent law is directly based on the invention, original invention. So our patent laws are protecting the original inventions, whichever is done by a person or any organization. A patent is a government issued right. And one more thing. So these intellectual property right can be can be these intellectual property, I suppose we are talking about patent. So these patents can be protected by government for a single person, for an organization. Even government can make patent for some invention if it was done by any government body. So it's not only like individual organization, government also can make patent their work if they have done something under their institute. A patent is a government issued right granted to individuals or groups that protect their original invention from being made, used, sold, or by other without their permission for set up period of time. So they have also a period of time. So we can see that invention in various field of technology like pharmaceuticals, biotechnology, computer hardware, computer software, all these things come under the patent law. So there are some patent is not a right to the invention. So patent is given on invention, but it is not, not a right to the invention, but a patent provides the right to exclude other from making, using, selling, offering for sale. So here it is saying that if you have created something, so it is not going to protect your invention. It is going to stop other. It is going to basically, it is not going to protect your invention. It is going to stop other to reproduce the same thing using your invention. They will exclude them from making, they will exclude them from using, selling, and offering for sale. So these things are protected under the patent law. So they are just, stopping others to use the patent what you have done through, what you have done patent under by your invention. So this is for 20 years. Patent is given for a term of 20 years. A patent is a limited property right that government offers to inventor in exchange of. So government is giving this on the exchange of an agreement that after 20 years, or if even you can have patent for 10 years, it's up to you. There is maximum 20 years, but it's up to you for 5 years, 10 years, 15, how many years you want to go for the patent. And after that you have to made it public. So on this ground, government gives protection to the patent and invention under patent. So there are three criteria for patent exam. First is novelty, means something should be a completely new. Second is non-obviousness, means something is not that, a skilled person in that field already knows that, this thing is this thing. So that should be non-obvious. मतलब देखने से ही नहीं लगता कि नहीं नहीं ये ऐसा, ये नॉर्मल चीज़ है, कोई स्पेसिफिक चीज़ नहीं है. So it should be a non-obvious. Next is industrial application, means it should be used for industrial purpose, and it should use for some economic purpose. So there a patent is basically an economic right. The grant and enforcement are patent are governed by national law. So these are governed by national laws, and there are also some international treaties regarding the patent. So that is, what we have discussed in question, that they have territorial application. In India, a patent is granted for a 20 years, after which the monopoly left. So every country has their different, a term of the patent or copyright. Like if you will go to the US and I think in US they have patent for 70 years. In India we are giving, sorry, not patent, copyright. And in India we are giving the lifetime plus 60 years. But in Europe they are giving 50 years. So it is territorial based how much term of, I mean they are giving the right for that invention or expression, whatever it is. The Patent Act 1970 defines what is invention. Means a new product or process involving an inventive step and capable of industrial application. So it should be industrial application, then your patent would be recognized. There are some product and process that are non-patentable in India. So there are also some products which cannot be patentable, like mere discovery of a scientific principle. If you are discovering some very fundamental scientific principle, or invention like for instance, or formulation of an abstract theory, discovering of any living thing or non-living substance occurring in nature. So suppose there are many kinds of butterflies in the world. So some new kind of butterfly, someone went and discovered it. So you cannot make patent over that. So we are seeing in news that some new type of plant is discovered, some new type of animal is discovered. So they cannot be patent. I mean we cannot make patent in India. And secondly, invention related to atomic energy. So any invention related to atomic energy is not patentable in India. So remember these things, that there are something which are also not patentable. Now we are coming to the trademark. What is trademark? Trademark is something, a distinguished mark or sign, कोई जो कि चीज़ जो दूसरे से अलग करता हो, आई मीन मेक इट्स अ डिफरेंट इम्प्रेशन और साइन. एंड दैट ऑल्सो, और इसका काम क्या हो, दैट इट शुड ऑल्सो रिप्रेजेंट अ पर्टिकुलर ब्रांड और कंपनी. So I can show you some examples here. So by looking, you people can tell about this. Has anyone heard about this IKEA? No one? Okay. Anyone heard about this IBM?
Yes, sir.
Okay. IBM is related to what? What thing IBM do? You people don't have idea.
Software.
It make computer software, and earlier they were also making computers. They are making software, computer software. Okay, you people would have at least know this Intel, this logo of Facebook. So these are the basically trademarks by which we, I mean by just looking we can tell their brand and company. We also by just looking this name of Samsung, we trust their products, we know what qualities are there. So these are the examples of trademark. So the objective of having a trademark is to provide a distinct mark or origin of a class of goods. तो एक अलग तरीके का, एक अलग क्लास ऑफ गुड्स जो है वो उससे रिप्रेजेंट किया जाता है. And to distinguish those goods from other, and making difference with other goods. So if on a mobile phone a Samsung is written, so first thing is tell about it is Samsung, and another thing that if a mobile do not have written Samsung over that, it also tells that it is not Samsung. So it's easily differentiate from one brand to another brand, one product, one good to another. And हमारे दिमाग में क्या आता है, what we see when we look to the Samsung is very trusted brand, which we can see in India. I mean, so whenever we look see Samsung, we say that this is trustable, this is a long lasting, I mean, phone. So something like that comes in our mind. So these things are done by their trademark. It shows some quality and standard which are established by the brand. The work are to be registered patent and trademark office में ये register किया जाता है trademark को. and this lasts for 10 years, but after that it can be continuously renewed any number of times for again the next 10-year period. So for 10 year 10 year 10 year, I mean you have to register it to the patent and trademark office. Where it is written? It is written in section 25 of the Trademarks Act 1999. So if anyone is violating this, there can be a criminal remedy. I mean, will get. I mean, company will get the criminal remedy if someone is infringing or violating the trademark rights. So section 2ZB of the Trademark Act 1999 defines what is trademark. So means a mark capable of being represented graphically and which is capable of distinguishing, means differentiating the goods or service of one person from those of others. एक person का I mean जो thing है वो I mean differentiating from another. Shape of goods, their package, combination of colors, these things are also part of trademark. Then what is mark? Section 2M of the Trademark Act define that a device, brand, heading, label, ticket, name, signature, word, letter, all these things constitute the mark. Shape of good, packaging, combination of colors, and all these things. Now we, by just looking, we can have idea that these are the trademarks. So there are different type of trademarks we have just read here: their shape, their packaging, signature, word, letters, name, these marks. So here it is an example you can see. Their shape is also showing a kind of trademark. Their name, their symbol, their slogan, their color, their logo type, these are all the part of trademarks. Now we are moving to the geographical indications. Geographical indications are used to identify goods that have a specific geographical origin. मतलब it means that something or some good which are very prominent to a particular area and from where it is known to the other region or whole nation or even at an international level, that should be popular and possess a quality, reputation, and other characteristic of that place of origin. And when a government give a GI tag, I mean it also gives, I mean it's kind of giving assurance that of its quality, its distinctiveness, which is essentially attributed to its origin area, where locality, region, or country. So we can have some example like Darjeeling tea. Can anyone tell where is Darjeeling? Darjeeling in the North Bengal.
Uttarakhand.
Darjeeling is Uttarakhand. Darjeeling in West Bengal. Not,
Uttarakhand.
No, North Bengal. Bengal.
North Bengal. Darjeeling is in North Bengal. You people would have heard about the Naxal Bari district, from where Naxalism, I mean, that started. So Naxal Bari is a district. I mean, under that district, this Darjeeling place is there in North West Bengal. Okay, so Darjeeling tea, champagne, tequila, these are the alcoholic drinks which are famous. Florida orange. Can anyone tell where is Florida? So these are the international example. Florida is an state of USA. New Zealand in America. So New Zealand lamb. So these are the international examples of the geographical indications. And some of the regional we can see: basmati rice, Darjeeling tea, Kanchipuram silk sari. Can anyone tell where is this place Kanchipuram?
Tamil Nadu.
Yeah, Tamil Nadu. In Tamil Nadu, there is a famous city, historical city, Kanchipuram. Alfonso mango, Nagpur orange. Nagpur is in
Maharashtra.
Nagpur in Maharashtra. Kolhapuri chappal, Bikaneri bhujia. Where is this Bikaner?
Maharashtra,
Rajasthan.
Rajasthan.
Bikaner is in Rajasthan. So these places are, I mean, these products are associated sometimes with their place name also, like Kanchipuram, Kolhapuri, Bikaneri, all these things. And sometimes they do not get the name of their place, but they symbolize that they are coming from a specific area and they are famous for some specific quality and some different nature of that product. So these things are come under the GI tag. So the Geographical Indication of Goods Registration and Protection Act 1999 deal with the geographical indication. So here good means what goods come under the GI? It can be agricultural good, natural good, handicrafts good, manufactured goods, or any goods of any goods or of in sorry two time of is written, any goods or industrial goods including the foodstuffs. So these GI tags are given for the 10 period, but they can be renewed and number of times, but you have to renew it after 10 year, every 10 year. Where it is written? It is written in section 18 of the GI Goods Act 1999. Then next come the industrial design. So industrial design is deal with the Industrial Design Act 2000. So we can see that these except the Copyright Act which came in 1857, most of these I mean intellectual property related acts came in either 2000 or near to 2000. Like here it came in 1999, it came in the 2000. So you should also have some idea about these acts. So what is design? I mean design defined in section 2D means only the features of shape, configuration, pattern, ornament, composition of lines or colors applied to any article. So these things are making the design. It can be in a two dimension, a design can be in two dimension, or it can be in a three dimensional, or in both form by any industrial process. या किसी भी industrial process से I mean it would have been created by any industrial process, whether manual, mechanical or chemical, separate or combined. So this is the basic I mean definition of industrial design. What it is? It's a shape, configuration, pattern, ornament, lines and colors. And it should be judged solely by the eye. I mean देख के ही लगना चाहिए, मतलब something about this industrial design. When applied to a functional article produces or increase, so it increases the aesthetics, it improves whatever product it is, it improves the visual appearance of the design, be it to a two-dimensional or three-dimensional. So it increases aesthetics and it improves the visual appearance. I mean industrial design improves the visual appearance and increase aesthetic. As per the Indian law under the Industrial Design Act of 2000, industrial design protection is a type of intellectual property right that gives the exclusive right to make, sell or use the article. So industrial design gives the exclusive right to make, to sell and use article, something like the patent. Industrial design is given for the I mean their term is for 10 years, their protection is given for 10 years, but it can be renewed only one more time for 5 years. So maximum 15 years, one time 10 years and another time 5 years. So 15 years I mean industrial design can be given protection. Section 11 of copyright, section 11 explains copyright on registration. So this basically whatever it is written here, it is explained with the help of the section 11 of the Industrial Design Act of 2000 and by the section 2. That first I mean it is given for 10 years, another time it is given for the 5 years. You people can read it. So there are some examples of industrial designs. their design of this chair, design of this chair, design of this bike, design of this laptop, or anything like this bottle, car. So these are the examples of industrial design. This Nokia phone, I mean this design of this keypad, design of these are protected. I mean if anyone has registered it, another person cannot copy the same design. If anybody would copy, there would be some remedy. I mean that company can approach to the court. These sound, these watch, so all those things. So now the trade secrets. What are the trade secrets? So trade secrets, I mean basically there is no specific enactment. I mean there is no specific laws is made on the trade secret till yet in our country. It is mainly deal by the Indian Contract Act 1872, IT Act of 2000, Copyright Law of 1857, and other common law action of breach of confidence. All so it is deal on these laws. I mean, there is no specific enactment made on the trade secret in our country. So, what are the trade secrets? It can be, I mean, it includes business strategies, proposal, client database, information, compilations, design, program, drawing, devices, formula, and composition. So, these are the part of the trade secrets. So, what World Intellectual Property Organization said about it? That trade secrets are intellectual property rights on confidential information, may be sold or licensed. So it can be sold and it can be licensed also. So what I mean for qualifying a trade secret, I mean there are some characters should be, it should have some
हेलो
character. Yes, yes.
सर जो पैकेट के पीछे सर जो इंग्रेडिएंट्स दिया रहता है वो भी ट्रेड सीक्रेट में आता है
नहीं, वो ट्रेड सीक्रेट में नहीं आता है, बिकॉज दे हैव ऑलरेडी मेक इट पब्लिक ना. So I'm going to read what are the, I mean what should be the what should be there, I mean what should be their quality and under which we should qualify as a trade secret. So first thing is that it should be a commercially viable, मतलब ट्रेड के लिए अच्छा हो, मतलब इकोनॉमिकल पर्पस के लिए अच्छा हो, बेचने के लिए अच्छा हो. To be known only a limited group of person, and it should be known to some people, and it should be and there should be a reasonable steps taken by the right holder of information to keep it secret. And और इसके लिए एक स्टेप लिया गया हो by the company to keep it also secret, to make it confidential. So all these things defines what is the trade secret. First it should be commercially viable, then their secret is known to a limited people, and company should also take the reasonable step to make it, to keep it secret. So I can give you an example. आप लोगों ने मैगी देखा होगा. On packet of Maggi there is written, I mean what are the ingredients in that, but they didn't release how they made using those ingredients, how they made it to that form, because other companies are also using the same ingredient, but their taste is different, Maggie's taste is different. So that is the trade secret, how they are using those ingredients to make it into that form. So that is trade secret. See how they are making it using the same ingredient. So that comes under the trade secret. We can see this, a single product can have protected through a multiple intellectual property right, like its logo. Here its logo is there, if you can see, Coca-Cola. So their logo comes under the trademark, and the shape of bottle, this bottle shape you can see here, this is designed through the industrial design. But their bottling equipment, they would have used some machines to I mean to make this bottle, and to tight this bottle, I mean all these things. So they have used some machines, so on that they can have patent. Then next is copyright. Whatever text is written over there, whatever database is there, or on their website, Coca-Cola's website, there would be some artistic line or something, artistic painting, or anything is created, that can be put under the copyright. So a single product can have the multiple copyright. Through this example, you can see that. So let's revise it through this chart. So patent is for 20 years, but it is mandatory that you should renewal it every year. So on first year you have patented it for a 1 year. Then again next year you have to patent it for another 1 year. Then again you have to patent it for another 1 year. So maximum time you can go to the 20 year, and it is deal by this the Patent Act 2005. It made in 1970, but it was amended in 2005. So Patent Act 2005. Next comes trademark. Trademark can have lifelong. I mean, it should be renewed after 10 years. So one time you have made a uh, get this protected under the Trademark Act. Then again after 10 years you have to renew it. So the Trademarks Act 1999, which amended in 2010. Next is design. Design is for maximum 15 years. As I have already told, first you will get a protection for 10 years, then again you will get a protection for 5 years. So maximum is 15 years. Copyright is 60 years. I mean after the death, it is 60 years. And once your 60 years completed, it would be put in the public domain. And this is deal through the Copyright Act 1957, which is also amended in 2012. Then come the GI, geographical indication. It can be a lifelong. I mean on every 10 years you have to just renew it if you want to, as much long as you want to hold it as a GI. And it was deal under the GI Goods Act 1999. So this is the chart which you can utilize to revise your concept. So all the basic things are covered in this chart, but if some deeper question come, for that you have to read the other slides too. Next we are going to deal with the international organization and their treaties. UN Agency World Intellectual Property WIPO, which is based in Geneva. What it does, it administers the treaties in the field of intellectual property. So it helps in making treaties to nation or multiple nation on the in the field of intellectual property. इंडिया इज अ मेंबर ऑफ टू मेजर ट्रीटीज. इंडिया जो है वो दो बड़े ट्रीटीज का पार्ट है, पार्ट ऑफ टू बिग ट्रीटीज. फर्स्ट इज पेरिस कन्वेंशन फॉर द प्रोटेक्शन ऑफ इंडस्ट्रियल प्रॉपर्टी which is related to patent, trademark, design, etc. of 1883. And second one is the Berne Convention for the protection of literary act, artistic work, which is related to copyright of 1886. So India is the member of these two major treaties regarding the IPR. India is also a member of World Trade Organization. World Trade Agreement contain an aspect of intellectual property. There is an agreement on intellectual property under the WTO. That is TRIPS, trade related aspect of intellectual property. So the agreement made protection of intellectual property is enforceable obligation. So whoever has signed this TRIPS, so this agreement is also enforceable obligation on the member states of the World Trade Organization. And there are some minimum standards of the intellectual property for the member states. So World Trade Organization through this agreement had some minimum criteria, and there are some enforceable obligations too. So I will suggest you to once go and read about these TRIPS and these two major treaties. So briefly go on Google and briefly read about this if might some question come on this topic. Otherwise all things are covered through all these 24 slides. So if anyone have any doubt, so we can discuss over that. Is there any doubt? So I will suggest you to revise it as much as possible and save this. I will put this in group. So save this for the later revision. Is there any doubt? No doubts?